Hello, everyone. Today's case is Youngstown Sheet and Tube Company v. Sawyer. So the background on this is back in the 1950s, there was going to be a strike. I think it was like a steel strike, and President Truman was going to seize the steel mills to stop the strike because he thought it was going to interfere with the Korean War, and it got all the way to Supreme Court. And let's see what the Supreme Court said. And also, this is well known for Justice Jackson's concurrence about the relationship between presidential power and congressional power and how where the overlaps are. And we'll get to that. Okay, so to avert a nationwide strike of steelworkers in April 1952, which he believed would jeopardize national defense, the president issued an executive order directing the Secretary of Commerce to seize and operate most of the steel mills. The order was not based upon any specific statutory authority, but was based generally upon all powers vested in the president by the Constitution and laws of the United States, and as President of the United States and Commander-in-Chief of the Armed Forces. The Secretary issued an order seizing the steel mills and directing their presidents to operate them as operating managers for the United States in accordance with his regulations and directions. The president promptly reported these events to Congress, but Congress took no action. It had provided other methods of dealing with such situations and had refused to authorize governmental seizures of property to settle labor disputes. The steel companies sued the secretary in a federal district court, praying for a declaratory judgment and injunctive relief. The district court issued a preliminary injunction, which the Court of Appeals held. Although this case has proceeded no further than the preliminary injunction stage, it is ripe for determination of the constitutional validity of the executive order on the record presented. Under prior decisions of this court, there is doubt as to the right to recover in the Court of Claims on account of properties unlawfully taken by government officials for public use. Seizure and governmental operation of these going businesses were bound to result in many present and future damages of such nature as to be difficult, if not incapable, of measurement. The executive order was not authorized by the Constitution or laws of the United States, and it cannot stand. There is no statute which expressly or impliedly authorizes the president to take possession of this property as he did here. In its consideration of the Taft-Hartley Act in 1947, Congress refused to authorize governmental seizures of property as a method of preventing work stoppages and settling labor disputes. Authority of the president to issue such an order in the circumstances of this case cannot be implied from the aggregate of his powers under Article 2 of the Constitution. The order cannot properly be sustained as an exercise of the president's military power as commander-in-chief of the armed forces, nor can the order be sustained because of the several provisions of Article 2 which grant executive power to the president. The power here sought to be exercised is the lawmaking power, which the Constitution vests in the Congress alone, in both good and bad times. Even if it be true that other presidents have taken possession of private business enterprises without congressional authority in order to settle labor disputes, Congress has not thereby lost its exclusive constitutional authority to make the laws necessary and proper to carry out all powers vested by the Constitution in the government of the United States or any department or officer thereof. Affirmed. For the concurring opinions, for the dissenting opinions, the district court issued a preliminary injunction restraining the Secretary of Commerce from carrying out the terms of Executive Order number 10340. The Court of Appeals issued a stay. This court granted certiorari. The judgment of the district court is affirmed. And then this is the counsel, and then here's the opinion. Mr. Justice Black delivered the opinion of the court. We are asked to decide whether the president was acting within his constitutional power when he issued an order directing the Secretary of Commerce to take possession of and operate most of the nation's steel mills. The mill owners argue that the president's order amounts to lawmaking, a legislative function which the Constitution has expressly confided to the Congress and not to the president. The government's position is that the order was made on findings of the president that his action was necessary to avert a national catastrophe which would inevitably result from a stoppage of steel production, and that in meeting this grave emergency, the president was acting within the aggregate of his constitutional powers as the nation's chief executive and the commander-in-chief of the armed forces of the United States. The issue emerges here from the following series of events. In the latter part of 1951, a dispute arose between the steel companies and their employees over terms and conditions that should be included in new collective bargaining agreements. Long continued conferences failed to resolve the dispute. On December 18, 1951, the employees' representative, United Steelworkers of America, CIO, gave notice of an intention to strike when the existing bargaining agreements expired on December 31st. The Federal Mediation and Conciliation Service then intervened in an effort to get labor and management to agree. This failing, the president on December 22nd, 1951, referred the dispute to the Federal Wage Stabilization Board to investigate and make recommendations for fair and equitable terms of settlement. This board's report resulted in no settlement. On April 4th, 1952, the union gave notice of a nationwide strike called to begin at 12:01 a.m., April 9th. The indispensability of steel as a component of substantially all weapons and other war materials led the president to believe that the proposed work stoppage would immediately jeopardize our national defense and that governmental seizure of the steel mills was necessary in order to assure the continued availability of steel. Reciting these considerations for his action, the president, a few hours before the strike was to begin, issued Executive Order 10340, a copy of which is attached as an appendix. The order directed the Secretary of Commerce to take possession of most of the steel mills and keep them running. The Secretary immediately issued his own possessory orders, calling upon the presidents of the various seized companies to serve as operating managers for the United States. They were directed to carry on their activities in accordance with regulations and directions of the Secretary. The next morning, the president sent a message to Congress reporting his action. 12 days later, he sent a second message. Congress has taken no action. Obeying the Secretary's orders under protest, the companies brought proceedings against him in the district court. Their complaints charged that the seizure was not authorized by an act of Congress or by any constitutional provisions. The district court was asked to declare the orders of the President and the Secretary invalid and to issue preliminary and permanent injunctions restraining their enforcement. Opposing the motion for preliminary injunction, the United States asserted that a strike disrupting steel production for even a brief period would so endanger the well-being and safety of the nation that the president had inherent power to do what he had done, supported by the Constitution, by historical precedent, and by court decisions. The government also contended that in any event, no preliminary injunction should be issued because the companies had made no showing that their available legal remedies were inadequate or that their injuries from seizure would be irreparable. Holding against the government on all points, the district court on April 30th issued a preliminary injunction restraining the secretary from continuing the seizure and possession of the plants and from acting under the purported authority of Executive Order number 10340. On the same day, the Court of Appeals stayed the district court's injunction. Deeming it best that the issues raised be promptly decided by this court, we granted certiorari on May 3rd and set the cause for argument on May 12th. Two crucial issues have developed. First, should final determination of the constitutionality of the President's order be made in this case, which has proceeded no further than the preliminary injunction stage? Second, if so, is the seizure order within the constitutional power of the President? It is urged that there were non-constitutional grounds upon which the district court could have denied the preliminary injunction and thus have followed the customary judicial practice of declining to reach and decide constitutional questions until compelled to do so. On this basis, it is argued that equity's extraordinary injunctive relief should have been denied because A, seizure of the company's properties did not inflict irreparable damages, and B, there were available legal remedies adequate to afford compensation for any possible damages which they might suffer. While separately argued by the government, these two contentions are here closely related, if not identical. Arguments as to both rest in large part on the government's claim that should the seizure ultimately be held unlawful, the companies could recover full compensation in the Court of Claims for the unlawful taking. Prior cases in this court have cast doubt on the right to recover in the Court of Claims on account of properties unlawfully taken by government officials for public use, as these properties were alleged to have been. Moreover, seizure and governmental operation of these going businesses were bound to result in many present and future damages of such nature as to be difficult, if not incapable, of measurement. Viewing the case this way, and in the light of the facts presented, the district court saw no reason for delaying decision of the constitutional validity of the orders. We agree with the district court and can see no reason why that question was not ripe for determination on the record presented. We shall therefore consider and determine that question now. The President's power, if any, to issue the order must stem either from an act of Congress or from the Constitution itself. There is no statute that expressly authorizes the President to take possession of property as he did here, nor is there any act of Congress to which our attention has been directed, from which such a power can fairly be implied. Indeed, we do not understand the government to rely on statutory authorization for this seizure. There are two statutes which do authorize the President to take both personal and real property under certain conditions. However, the government admits that these conditions were not met and that the President's order was not rooted in either of the statutes. The government refers to the seizure provisions of one of these statutes, subsection 201B of the Defense Production Act, as much too cumbersome, involved, and time-consuming for the crisis which was at hand. Moreover, the use of the seizure technique to solve labor disputes in order to prevent work stoppages was not only unauthorized by any congressional enactment prior to this controversy, Congress had refused to adopt that method of settling labor disputes. When the Taft-Hartley Act was under consideration in 1947, Congress rejected an amendment which would have authorized such governmental seizures in cases of emergency. Apparently, it was thought that the technique of seizure, like that of compulsory arbitration, would interfere with the process of collective bargaining. Consequently, the plan Congress adopted in that act did not provide for seizure under any circumstances. Instead, the plan sought to bring about settlements by use of the customary devices of mediation, conciliation, investigation by boards of inquiry, and public reports. In some instances, temporary injunctions were authorized to provide cooling off periods. All this failing, unions were left free to strike after a secret vote by employees as to whether they wished to accept their employer's final settlement offer. It is clear that if the President had authority to issue the order he did, it must be found in some provision of the Constitution, and it is not claimed that express constitutional language grants this power to the President. The contention is that presidential power should be implied from the aggregate of his powers under the Constitution. Particular reliance is placed on provisions in Article 2, which says that the executive power shall be vested in a president, that he shall take care that the laws be faithfully executed, and that he shall be commander-in-chief of the Army and Navy of the United States. The order cannot properly be sustained as an exercise of the president's military power as commander-in-chief of the armed forces. The government attempts to do so by citing a number of cases upholding broad powers in military commanders engaged in day-to-day fighting in a theater of war. Such cases need not concern us here. Even though theater of war be an expanding concept, we cannot, with faithfulness to our constitutional system, hold that the commander-in-chief of the armed forces has the ultimate power as such to take possession of private property in order to keep labor disputes from stopping production. This is a job for the nation's lawmakers, not for its military authorities. Nor can the seizure order be sustained because of the several constitutional provisions that grant executive power to the President. In the framework of our Constitution, the President's power to see that the laws are faithfully executed refutes the idea that he is to be a lawmaker. The Constitution limits his functions in the lawmaking process to the recommending of laws he thinks wise and the vetoing of laws he thinks bad. And the Constitution is neither silent nor equivocal about who shall make laws which the President is to execute. The first section of the first article says that all legislative powers herein granted shall be vested in a Congress of the United States. After granting many powers to the Congress, Article 1 goes on to provide that Congress may make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. The President's order does not direct that a congressional policy be executed in a manner prescribed by Congress. It directs that a presidential policy be executed in a manner prescribed by the President. The preamble of the order itself, like that of many statutes, sets out reasons why the President believes certain policies should be adopted, proclaims these policies as rules of conduct to be followed, and again, like a statute, authorizes a government official to promulgate additional rules and regulations consistent with the policy proclaimed and needed to carry that policy into execution. The power of Congress to adopt such public policies as those proclaimed by the order is beyond question. It can authorize the taking of private property for public use. It can make laws regulating the relationships between employers and employees, prescribing rules designed to settle labor disputes, and fixing wages and working conditions in certain fields of our economy. The Constitution does not subject this lawmaking power of Congress to presidential or military supervision or control. It is said that other presidents without congressional authority have taken possession of private business enterprises in order to settle labor disputes. But even if this be true, Congress has not thereby lost its exclusive constitutional authority to make laws necessary and proper to carry out the powers vested by the Constitution in the government of the United States, or any department or officer thereof. The founders of this nation entrusted the lawmaking power to the Congress alone in both good and bad times. It would do no good to recall the historical events, the fears of power, and the hopes for freedom that lay behind their choice. Such a review would but confirm our holding that this seizure order cannot stand. The judgment of the district court is affirmed. Mr. Justice Frankfurter, although the considerations relevant to the legal enforcement of the principle of separation of powers seem to me more complicated and flexible than may appear from what Mr. Justice Black has written, I join this opinion because I thoroughly agree with the application of the principle to the circumstances of this case, even though such differences in attitude toward this principle may be merely differences in emphasis and nuance. They can hardly be reflected by a single opinion for the court. Individual expression of views in reaching a common result is therefore important. And then this is the executive order. Okay. Mr. Justice Frankfurter concurring. Before the cares of the White House were his own, President Harding is reported to have said that government, after all, is a very simple thing. He must have said that if he said it as a fleeting inhabitant of fairyland, the opposite is the truth. A constitutional democracy like ours is perhaps the most difficult of man's social arrangements to manage successfully. Our scheme of society is more dependent than any other form of government on knowledge and wisdom and self-discipline for the achievement of its aims. For our democracy implies the reign of reason on the most extensive scale. The founders of this nation were not imbued with the modern cynicism that the only thing that history teaches is that it teaches nothing. They acted on the conviction that the experience of man sheds a good deal of light on his nature. It sheds a good deal of light not merely on the need for effective power, if a society is to be at once cohesive and civilized, but also on the need for limitations on the power of governors over the governed. To that end, they rested the structure of our central government on the system of checks and balances. For them, the doctrine of separation of powers was not mere theory. It was a felt necessity. Not so long ago, it was fashionable to find our system of checks and balances obstructive to effective government. It was easy to ridicule that system as outmoded, too easy. The experience through which the world has passed in our own day has made vivid the realization that the framers of our Constitution were not inexperienced doctrinaires. These long-headed statesmen had no illusion that our people enjoyed biological or psychological or sociological immunities from the hazards of concentrated power. It is absurd to see a dictator in a representative product of the sturdy democratic traditions of the Mississippi Valley. The accretion of dangerous power does not come in a day. It does come, however slowly, from the generative force of unchecked disregard of the restrictions that fence in even the most disinterested assertion of authority. The framers, however, did not make the judiciary the overseer of our government. They were familiar with the revisory functions entrusted to judges in a few of the states and refused to lodge such powers in this court. Judicial power can be exercised only as to matters that were the traditional concern of the courts at Westminster, and only if they arise in ways that to the expert feel that, to the expert field of lawyers, constitute cases or controversies. Even as to questions that were the staple of judicial business, it is not for the courts to pass upon them unless they are indispensably involved in a conventional litigation, and then only to the extent that they are so involved. Rigorous adherence to the narrow scope of the judicial function is especially demanded in controversies that arouse appeals to the Constitution. The attitude with which this court must approach its duty when confronted with such issues is precisely the opposite of that normally manifested by the general public. So-called constitutional questions seem to exercise a mesmeric, mesmeric influence over the popular mind. This eagerness to settle, preferably forever, a specific problem on the basis of the broadest possible constitutional pronouncements may not unfairly be called one of our minor national traits. An English observer of our scene has acutely described it. At the first sound of a new argument over the United States Constitution and its interpretation, the hearts of Americans leap with a fearful joy. The blood stirs powerfully in their veins, and a new luster brightens their eyes. Like King Harry's men before Hartfleur, they stand like greyhounds in the slips, straining upon the start. The path of duty for this court, it bears repetition, lies in the opposite direction. Due regard for the implications of the distribution of powers in our Constitution and for the nature of the judicial process as the ultimate authority in interpreting the Constitution has not only confined the court within the narrow domain of appropriate adjudication, it has also led to a series of rules under which it has avoided passing upon a large part of all the constitutional questions pressed upon it for decision. A basic rule is the duty of the court not to pass on a constitutional issue at all, however narrowly it may be confined, if the case may, as a matter of intellectual honesty, be decided without even considering delicate problems of power under the Constitution. It ought to be, but apparently is not, a matter of common understanding that clashes between different branches of the government should be avoided if a legal ground of less explosive potentialities is properly available. Constitutional adjudications are apt, by exposing differences, to exacerbate them. So here, our first inquiry must be not into the powers of the president, but into the powers of a district judge, to issue a temporary injunction in the circumstances of this case. Familiar as that remedy is, it remains an extraordinary remedy. To start with a consideration of the relation between the president's powers and those of Congress, a most delicate matter that has occupied the thoughts of statesmen and judges since the nation was founded and will continue to occupy their thoughts as long as our democracy lasts, is to start at the wrong end. A plaintiff is not entitled to an injunction if money damages would fairly compensate him for any wrong he may have suffered. The same considerations by which the steelworkers, in their brief amicus, demonstrate from the seizure here, in controversy, consequences that cannot be translated into dollars and cents preclude a holding that only compensable damage for the plaintiffs is involved. Again, a court of equity ought not to issue an injunction, even though a plaintiff otherwise makes out a case for it, if the plaintiff's right to an injunction is overborne by a commanding public interest against it. One need not resort to a large epigrammatic generalization that the evils of industrial dislocation are to be preferred to allowing illegality to go unchecked. To deny inquiry into the president's power in a case like this, because of the damage to the public interest to be feared from upsetting its exercise by him, would in effect always preclude inquiry into challenged power, which presumably only avowed great public interest brings into action. And so, with the utmost unwillingness, with every desire to avoid judicial inquiry into the powers and duties of the other two branches of the government, I cannot escape consideration of the legality of Executive Order Number 10340. The pole star for constitutional adjudications is John Marshall's greatest judicial utterance, that it is a constitution we are expounding. That requires both a spacious view in applying an instrument of government made for an undefined and expanding future, and as narrow a delimitation of the constitutional issues as the circumstances permit. Not the least characteristic of great statesmanship which the framers manifested was the extent to which they did not attempt to bind the future. It is no less incumbent upon this court to avoid putting fetters upon the future by needless pronouncements today. Marshall's admonition that it is a constitution we are expounding is especially relevant when the court is required to give legal sanctions to an underlying principle of the Constitution, that of separation of powers. The great ordinances of the Constitution do not establish and divide fields of black and white. The issue before us can be met, and therefore should be, without attempting to define the President's powers comprehensively. I shall not attempt to delineate what belongs to him by virtue of his office beyond the power even of Congress to contract. What authority belongs to him until Congress acts, what kind of problems may be dealt with either by the Congress or by the President, or by both. What power must be exercised by the Congress and cannot be delegated to the President. It is as unprofitable to lump together in an undiscriminating hodgepodge past presidential actions claimed to be derived from occupancy of the office as it is to conjure up hypothetical future cases. The judiciary may, as this case proves, have to intervene in determining where authority lies as between the democratic forces in our scheme of government. But in doing so, we should be wary and humble. Such is the teaching of this court's role in the history of the country. It is in this mood and with this perspective that the issue before the court must be approached. We must therefore put to one side consideration of what powers the President would have had if there had been no legislation whatever bearing on the authority asserted by the seizure, or if the seizure had been only for a short, explicitly temporary period, to be terminated automatically unless congressional approval were given. These and other questions, like or unlike, are not now here. I would exceed my authority were I to say anything about them. The question before the court comes in this setting. Congress has frequently, at least 16 times since 1916, specifically provided for executive seizure of production, transportation, communications, or storage facilities. In every case, it has qualified this grant of power with limitations and safeguards. This body of enactments, as summarized in tabular form in Appendix 1, demonstrates that Congress deemed seizure so drastic a power as to require that it be carefully circumscribed whenever the President was vested with this extraordinary authority. The power to seize has uniformly been given only for a limited period or for a defined emergency, or has been repealed after a short period. Its exercise has been restricted to particular circumstances such as time of war or when war is imminent, the needs of public safety or of national security or defense, or urgent and impending need. The period of governmental operation has been limited, as for instance, to 60 days after the restoration of productive efficiency. Seizure statutes usually make executive action dependent on detailed conditions, for example, A, failure or refusal of the owner of a plant to meet governmental supply needs, or B, failure of voluntary negotiations with the owner for the use of a plant necessary for great public ends. Congress often has specified the particular executive agency which should seize or operate the plants or whose judgment would appropriately test the need for seizure. Congress also has not left to implication that just compensation be paid. It has usually legislated in detail regarding enforcement of this litigation breeding general requirement. Congress in 1947 was again called upon to consider whether governmental seizure should be used to avoid serious industrial shutdowns. Congress decided against conferring such power generally and in advance without special congressional enactment to meet each particular need. Under the urgency of telephone and coal strikes in the winter of 1946, Congress addressed itself to the problems raised by national emergency strikes and lockouts. The determination of wartime seizure powers on December 31st, 1946, brought these matters to the attention of Congress with vivid impact. A proposal that the President be given powers to seize plants to avert a shutdown where the health or safety of the nation was endangered was thoroughly canvassed by Congress and rejected. No room for doubt remains that the proponents as well as the opponents of the bill, which became the Labor Management Relations Act of 1947, clearly understood that as a result of that legislation, the only recourse for preventing a shutdown in any basic industry after failure of mediation was Congress. Authorization for seizure as an available remedy for potential dangers was unequivocally put aside. The Senate Labor Committee, through its chairman, explicitly reported to the Senate that a general grant of seizure powers had been considered and rejected in favor of a reliance on ad hoc legislation as a particular emergency might call for it. An amendment presented in the House providing that, where necessary to preserve and protect the public health and security, the President might seize any industry in which there is an impending curtailment of production, was voted down after debate by a vote of more than 3-1. In adopting the provisions which it did by the Labor Management Relations Act of 1947 for dealing with a national emergency arising out of a breakdown in peaceful industrial relations, Congress was very familiar with governmental seizure as a protective measure. On a balance of considerations, Congress chose not to lodge this power in the President. It chose not to make available in advance a remedy to which both industry and labor were fiercely hostile. In deciding that authority to seize should be given to the President only after full consideration of the particular situation should show such legislation to be necessary, Congress presumably acted on experience with similar industrial conflicts in the past. It evidently assumed that industrial shutdowns in basic industries are not instances of spontaneous generation, and that danger warnings are sufficiently plain before the event to give ample opportunity to start the legislative process into action. In any event, nothing can be plainer than that Congress made a conscious choice of policy in a field full of perplexity and peculiarly within legislative responsibility for choice. In formulating legislation for dealing with industrial conflicts, Congress could not more clearly and emphatically have withheld authority than it did in 1947. Perhaps as much so as is true of any piece of modern legislation, Congress acted with full consciousness of what it was doing and in the light of much recent history. Previous seizure legislation had subjected the powers granted to the President to restrictions of varying degrees of stringency. Instead of giving him even limited powers, Congress in 1947 deemed it wise to require the President, upon failure of attempts to reach a voluntary settlement, to report to Congress if he deemed the power of seizure a needed shot for his locker. The President could not ignore the specific limitations of prior seizure statutes. No more could he act in disregard of the limitation put upon seizure by the 1947 Act. It cannot be contended that the President would have had power to issue this order had Congress explicitly negated such authority in formal legislation. Congress has expressed its will to withhold this power from the President as though it had said so in so many words. The authoritatively expressed purpose of Congress to disallow such power to the President and to require him, when in his mind the occasion arose for such a seizure, to put the matter to Congress and ask for specific authority from it, could not be more decisive if it had been written into subsections 206 through 210 of the Labor Management Relations Act of 1947. Only the other day, we treated the congressional gloss upon those sections as part of the Act. Grafting upon the words "a purpose of Congress" thus unequivocally expressed is the regular legislative mode for defining the scope of an act of Congress. It would be not merely infelicitous draftsmanship, but almost offensive gaucherie to write such a restriction upon the President's power in terms into a statute rather than to have it authoritatively expounded, as it was, by controlling legislative history. By the Labor Management Relations Act of 1947, Congress said to the President, you may not seize, please report to us and ask for seizure power if you think it is needed in a specific situation. This, of course, calls for a report on the unsuccessful efforts to reach a voluntary settlement as a basis for discharge by Congress of its responsibility, which it has unequivocally reserved, to fashion further remedies than it provided. But it is now claimed that the President has seizure power by virtue of the Defense Production Act of 1950 and its amendments, and the claim is based on the occurrence of new events, Korea and the need for stabilization, etc. Although it was well known that seizure power was withheld by the Act of 1947, and although the President, whose specific requests for other authority were in the main granted by Congress, never suggested that in view of the new events, he needed the power of seizure, which Congress, in its judgment, had decided to withhold from him. The utmost that the Korean conflict may imply is that it may have been desirable to have given the president further authority, a freer hand in these matters. Absence of authority in the president to deal with a crisis does not imply want of power in the government. Conversely, the fact that power exists in the government does not vest it in the president. The need for new legislation does not enact it, nor does it repeal or amend existing law. No authority that has since been given to the president can, by any fair process of statutory construction, be deemed to withdraw the restriction or change the will of Congress as expressed by a body of enactments culminating in the Labor Management Relations Act of 1947. Title V of the Defense Production Act, entitled Settlement of Labor Disputes, pronounced the will of Congress that there be effective procedures for the settlement of labor disputes affecting national defense, and that primary reliance be placed upon the parties to any labor dispute to make every effort through negotiation and collective bargaining and the full use of mediation and conciliation facilities to effect a settlement in the national interest. Section 502 authorized the President to hold voluntary conferences of labor, industry, and public and government representatives, and to take such action as may be agreed upon in any such conference and appropriate to carry out the provisions of this title, provided that no action was taken inconsistent with the Labor Management Relations Act of 1947. This provision was set by the Senate Committee on Banking and Currency to contemplate a board similar to the War Labor Board of World War II, and a national labor management conference such as was held during World War II, when a no strike, no lockout pledge was obtained. Section 502 was believed necessary in addition to existing means for settling disputes voluntarily because the Federal Mediation and Conciliation Service could not enter a labor dispute unless requested by one party. Similar explanations of Title V were given in the conference report and by Senator Ives, a member of the Senate committee to whom Chairman Maybank, during the debates on the Senate floor, referred questions relating to Title V. Senator Ives said, "It should be remembered in this connection that during the period of the present emergency, it is expected that the Congress will not adjourn, but, at most, will recess only for very limited periods of time. If, therefore, any serious work stoppage should arise or even be threatened, in spite of the terms of the Labor Management Relations Act of 1947, the Congress would be readily available to pass such legislation as might be needed to meet the difficulty." The Defense Production Act affords no ground for the suggestion that the 1947 denial to the President of seizure powers has been impliedly repealed, and its legislative history contradicts such a suggestion. Although the proponents of that act recognized that the President would have a choice of alternative methods of seeking a mediated settlement, they also recognized that Congress alone retained the ultimate coercive power to meet the threat of any serious work stoppage. That conclusion is not changed by what occurred after the passage of the 1950 Act. 7.5 months later, on April 21st, 1951, the President, by Executive Order 10233, gave the reconstituted Wage Stabilization Board authority to investigate labor disputes, either 1. Submitted voluntarily by the parties, or 2. Referred to it by the President. The board can only make recommendations to the parties as to fair and equitable terms of settlement, unless the parties agree to be bound by the board's recommendations. About a month thereafter, subcommittees of both the House and Senate Labor Committees began hearings on the newly assigned disputes functions of the board. Amendments to deny the board these functions were voted down in the House, and Congress extended the Defense Production Act without changing Title V in relevant part. The legislative history of the Defense Production Act and its amendments in 1951 cannot possibly be vouched for more than congressional awareness and tacit approval that the President had charged with the Wage Stabilization Board with authority to seek voluntary settlement of labor disputes. The most favorable interpretation of the statements in the committee reports can make them mean no more than we are glad to have all the machinery possible for the voluntary settlement of labor disputes. In considering the Defense Production Act amendments, Congress was never asked to approve, and there is not the slightest indication that the responsible committees ever had in mind seizure of plants to coerce settlements of disputes. settlement of disputes. We are not even confronted by an inconsistency between the authority conferred on the wage board, as formulated by the executive order, and the denial of presidential seizure powers under the 1947 legislation. The board has been given merely mediatory powers similar to those of agencies created by the Taft-Hartley Act and elsewhere, with no other sanctions for acceptance of its recommendations than are offered by its own moral authority and the pressure of public opinion. The Defense Production Act and the disputes mediating agencies created subsequent to it still leave for solution elsewhere the question what action can be taken when attempts at voluntary settlement fail. To draw implied approval of seizure power from this history is to make something out of nothing. It is one thing to draw an intention of Congress from general language and to say that Congress would have explicitly written what is inferred, where Congress has not addressed itself to a specific situation. It is quite impossible, however, when Congress did specifically address itself to a problem, as Congress did to that of seizure, to find secreted in the interstices of legislation the very grant of power which Congress consciously withheld. To find authority so explicitly withheld is not merely to disregard in a particular instance the clear will of Congress, it is to disrespect the whole legislative process and the constitutional division of authority between President and Congress. The legislative history here canvassed is relevant to yet another of the issues before us, namely the government's argument that overriding public interest prevents the issuance of the injunction despite the illegality of the seizure. I cannot accept that contention. Balancing the equities when considering whether an injunction should issue is lawyers' jargon for choosing between conflicting public interests. When Congress itself has struck the balance, has defined the weight to be given the competing interests, a court of equity is not justified in ignoring that pronouncement under the guise of exercising equitable discretion. Apart from his vast share of responsibility for the conduct of our foreign relations, the embracing function of the President is that he shall take care that the laws be faithfully executed. The nature of that authority has, for me, been comprehensively indicated by Mr. Justice Holmes. The duty of the President to see that the laws be executed is a duty that does not go beyond the laws or require him to achieve more than Congress sees fit to leave within his power. The powers of the President are not as particularized as are those of Congress, but unenumerated powers do not mean undefined powers. The separation of powers built into our Constitution gives essential content to undefined provisions in the frame of our government. To be sure, the content of the three authorities of government is not to be derived from an abstract analysis. The areas are partly interacting, not wholly disjointed. The Constitution is a framework for government. Therefore, the way the framework has consistently operated fairly establishes that it has operated according to its true nature. Deeply embedded traditional ways of conducting government cannot supplant the Constitution or legislation, but they give meaning to the words of a text or supply them. It is an inadmissibly narrow conception of American constitutional law to confine it to the words of the Constitution and to disregard the gloss which life has written upon them. In short, a systematic, unbroken executive practice, long pursued to the knowledge of the Congress and never before questioned, engaged in by presidents who have also sworn to uphold the Constitution, making, as it were, such exercises of power part of the structure of our government, may be treated as a gloss on executive power, vested in the President by subsection 1 of Article 2. Such was the case of United States v. Midwest Oil Company. The contrast between the circumstances of that case and this one helps to draw a clear line between authority not explicitly conferred, yet authorized to be exercised by the President, and the denial of such authority. In both instances, it was the concern of Congress, under express constitutional grant, to make rules and regulations for the problems with which the President dealt. In the one case, he was dealing with the protection of property belonging to the United States, in the other with the enforcement of the Commerce Clause, and with raising and supporting armies and maintaining the Navy. In the Midwest Oil case, lands which Congress had opened for entry were, over a period of 80 years and in 252 instances, and by presidents learned and unlearned in the law, temporarily withdrawn from entry so as to enable Congress to deal with such such withdrawals. No remotely comparable practice can be vouched for executive seizure of property at a time when this country was not at war, in the only constitutional way in which it can be at war. It would pursue the irrelevant to reopen the controversy over the constitutionality of some acts of Lincoln during the Civil War. Suffice it to say that he seized railroads in territory where armed hostilities had already interrupted the movement of troops to the beleaguered capital, and his order was ratified by the Congress. The only other instances of seizures are those during the periods of the First and Second World Wars. In his 11 seizures of industrial facilities, President Wilson acted, or at least purported to act, under authority granted by Congress. Thus, his seizures cannot be adduced as interpretations by a president of his own powers, in the absence of statute. Down to the World War II period, then, the record is barren of instances comparable to the one before us. Of 12 seizures by President Roosevelt prior to the enactment of the War Labor Disputes Act in June 1943, 3 were sanctioned by existing law, and 6 others were effected after Congress, on December 8, 1941, had declared the existence of a state of war. In this case, reliance on the powers that flow from declared war has been commendably disclaimed by the Solicitor General. Thus, the list of executive assertions of the power of seizure in circumstances comparable to the present reduces to 3 in the 6-month period from June to December of 1941. We need not split hairs in comparing those actions to the one before us, though much might be said by way of differentiation, without passing on their validity. As we are not called upon to do, it suffices to say that these 3 isolated instances do not add up either in number, scope, duration, or contemporaneous legal justification to the kind of executive construction of the Constitution revealed in the Midwest oil case, nor do they come to us sanctioned by long-continued acquiescence of Congress, giving decisive weight to a construction by the executive of its powers. A scheme of government like ours, no doubt at times feels the lack of power to act with complete, all-embracing, swiftly moving authority. No doubt a government with distributed authority, subject to be challenged in the courts of law, at least long enough to consider and adjudicate the challenge, labors under restrictions from which other governments are free. It has not been our tradition to envy such governments. In any event, our government was designed to have such restrictions. The price was deemed not too high in view of the safeguards which these restrictions afford. I know no more impressive words on this subject than those of Mr. Justice Brandeis. The doctrine of the separation of powers was adopted by the Convention of 1787, not to promote efficiency, but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but by means of the inevitable friction incident to the distribution of the governmental powers among 3 departments, to save the people from autocracy. It is not a pleasant judicial duty to find that the president has exceeded his powers, and still less so when his purposes were dictated by concern for the nation's well-being, in the assured conviction that he acted to avert danger. But it would stultify one's faith in our people to entertain even a momentary fear that the patriotism and the wisdom of the president and the Congress, as well as the long view of the immediate parties in interest, will not find ready accommodation for differences on matters which, however close to their concern, and however intrinsically important, are overshadowed by the awesome issues which confront the world. When, at a moment of utmost anxiety, President Washington turned to this court for advice, and he had to be denied it as beyond the court's competence to give, Chief Justice Jay, on behalf of the court, wrote thus to the father of his country: "We exceedingly regret every event that may cause embarrassment to your administration, but we derive consolation from the reflection that your judgment will discern what is right, and that your usual prudence, decision, and firmness will surmount every obstacle to the preservation of the rights, peace, and dignity of the United States. In reaching the conclusion that conscience compels, I too derive consolation from the reflection that the President and the Congress between them will continue to safeguard the heritage which comes to them straight from George Washington." This is part of the appendix, I think. Skipping more of the appendix. Skipping. Okay. Mr. Justice Douglas concurring. There can be no doubt that the emergency which caused the president to seize these steel plants was one that bore heavily on the country. But the emergency did not create power. It merely marked an occasion when power should be exercised, and the fact that it was necessary that measures be taken to keep steel in production does not mean that the president, rather than the Congress, had the constitutional authority to act. The Congress, as well as the President, is trustee of the national welfare. The President can act more quickly than the Congress. The President, with the armed services at his disposal, can move with force as well as with speed. All executive power, from the reign of ancient kings to the rule of modern dictators, has the outward appearance of efficiency. Legislative power, by contrast, is slower to exercise. There must be delay while the ponderous machinery of committees, hearings, and debates is put into motion. That takes time. And while the Congress slowly moves into action, the emergency may take its toll in wages, consumer goods, war production, and standard of living of the people, and perhaps even lives. Legislative action may indeed often be cumbersome, time consuming, and apparently inefficient. But as Mr. Justice Brandeis stated in his dissent in Myers v. United States, the doctrine of the separation of powers was adopted by the Convention of 1787 not to promote efficiency, but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but by means of the inevitable friction incident to the distribution of the governmental powers among three departments, to save the people from autocracy. We therefore cannot decide this case by determining which branch of government can deal most expeditiously with the present crisis. The answer must depend on the allocation of powers under the Constitution. That in turn requires an analysis of the conditions giving rise to the seizure and of the seizure itself. The relations between labor and industry are one of the crucial problems of the era. Their solution will doubtless entail many methods: education of labor leaders and business executives, the encouragement of mediation and conciliation by the president, and the use of his great office in the cause of industrial peace, and the passage of laws. Laws entail sanctions, penalties for their violation. One type of sanction is fine and imprisonment. Another is seizure of property. And industry may become so lawless, so irresponsible as to endanger the whole economy. Seizure of the industry may be the only wise and practical solution. The method by which industrial peace is achieved is of vital importance, not only to the parties, but to society as well. A determination that sanctions should be applied, that the hand of the law should be placed upon the parties, and that the force of the courts should be directed against them, is an exercise of legislative power. In some nations, that power is entrusted to the executive branch as a matter of course, or in cases of emergencies. We chose another course. We chose to place the legislative power of the federal government in the Congress. The language of the Constitution is not ambiguous or qualified. It places not some legislative power in the Congress. Article 1, Section 1 says, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives." The legislative nature of the action taken by the President seems to me to be clear. When the United States takes over an industrial plant to settle a labor controversy, it is condemning property. The seizure of the plant is a taking in the constitutional sense. A permanent taking would amount to the nationalization of the industry. A temporary taking falls short of that goal. But though the seizure is only for a week or a month, the condemnation is complete, and the United States must pay compensation for the temporary possession. The power of the federal government to condemn property is well established. It can condemn for any public purpose, and I have no doubt but that condemnation of a plant, factory, or industry in order to promote industrial peace would be constitutional. But there is a duty to pay for all property taken by the government. The command of the Fifth Amendment is that no private property be taken for public use without just compensation. That constitutional requirement has an important bearing on the present case. The President has no power to raise revenues. That power is in the Congress by Article 1, Section 8 of the Constitution. The President might seize, and the Congress, by subsequent action, might ratify the seizure. but until and unless Congress acted, no condemnation would be lawful. The branch of government that has the power to pay compensation for a seizure is the only one able to authorize a seizure or make lawful one that the president has effected. That seems to me to be the necessary result of the condemnation provision in the Fifth Amendment. It squares with the theory of checks and balances expounded by Mr. Justice Black in the opinion of the court in which I join. If we sanctioned the present exercise of power by the President, we would be expanding Article 2 of the Constitution and rewriting it to suit the political conveniences of the present emergency. Article 2, which vests the executive power in the President, defines that power with particularity. Article 2, Section 2 makes the Chief Executive the Commander in Chief of the Army and Navy, but our history and tradition rebel at the thought that the grant of military power carries with it authority over civilian affairs. Article 2, Section 3 provides that the President shall, from time to time, give to the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. The power to recommend legislation granted to the President serves only to emphasize that it is his function to recommend and that it is the function of the Congress to legislate. Article 2, Section 3 also provides that the President shall take care that the laws be faithfully executed. But as Mr. Justice Black and Mr. Justice Frankfurter point out, the power to execute the laws starts and ends with the laws Congress has enacted. The great office of President is not a weak and powerless one. The president represents the people and is their spokesman in domestic and foreign affairs. The office is respected more than any other in the land. It gives a position of leadership that is unique. The power to formulate policies and mold opinion inheres in the presidency and conditions our national life. The impact of the man and the philosophy he represents may at times be thwarted by the Congress. Stalemates may occur when emergencies mount, and the nation suffers for lack of harmonious reciprocal action between the White House and Capitol Hill. That is a risk inherent in our system of separation of powers. The tragedy of such stalemates might be avoided by allowing the president the use of some legislative authority. The framers, with memories of the tyrannies produced by a blending of executive and legislative power, rejected that political arrangement. Some future generation may, however, deem it so urgent that the president have legislative authority that the Constitution will be amended. We could not sanction the seizures and condemnations of the steel plants in this case without reading Article 2 as giving the president not only the power to execute the laws, but to make some. Such a step would most assuredly alter the pattern of the Constitution. We pay a price for our system of checks and balances, for the distribution of power among the three branches of government. It is a price that today may seem exorbitant to many. Today, a kindly president uses the seizure power to effect a wage increase and to keep the steel furnaces in production. Yet tomorrow, another president might might use the same power to prevent a wage increase, to curb trade unionists, to regiment labor as oppressively as industry thinks it has been regimented by this seizure. Mr. Jackson, concurring in the judgment and opinion of the court, that comprehensive and undefined presidential powers holds both practical advantages and grave dangers for the country will impress anyone who has served as legal advisor to a president in time of transition and public anxiety. This is Mr. Justice Jackson concurring in the judgment and opinion of the court. While an interval of detached reflection may temper teachings of that experience, they probably are a more realistic influence on my views that the conventional materials of judicial decision which seem unduly to accentuate doctrine and legal fiction. But as we approach the question of presidential power, we have overcome mental hazards by recognizing them. The opinions of judges, no less than executives and publicists, often suffer the infirmity of confusing the issue of a power's validity with the cause it is invoked to promote, of confounding the permanent executive office with its temporary occupant. The tendency is strong to emphasize transient results upon policies, such as wages or stabilization, and lose sight of enduring consequences upon the balanced power structure of our republic. A judge, like an executive advisor, may be surprised at the poverty of really useful and unambiguous authority applicable to concrete problems of executive power as they actually present themselves. Just what our forefathers did envision or would have envisioned had they foreseen modern conditions, must be divined from materials almost as enigmatic as the dreams Joseph was called upon to interpret for Pharaoh. A century and a half of partisan debate and scholarly speculation yields no net result, but only supplies more or less apt quotations from respected sources on each side of any question. They largely cancel each other. And court decisions are indecisive because of the judicial practice of dealing with the largest questions in the most narrow way. The actual art of governing under our Constitution does not and cannot conform to judicial definitions of the power of any of its branches based on isolated clauses, or even single articles torn from context. While the Constitution diffuses power, the better to secure liberty, it also contemplates that practice will integrate the dispersed powers into a workable government. It enjoins upon its branches separateness but interdependence, autonomy but reciprocity. Presidential powers are not fixed but fluctuate, depending upon their disjunction or conjunction with those of Congress. We may well begin by a somewhat oversimplified grouping of practical situations in which a president may doubt, or others may challenge, his powers, and by distinguishing roughly the legal consequences of his factor of relativity. So it's actually Jackson who's got the famous concurrence, not Frankfurter. When the president acts pursuant to an express or implied authorization of Congress, his authority is at its maximum, for it includes all that he possesses in his own right, plus all that Congress can delegate. In these circumstances, and in these only, may he be said, for what it may be worth, to personify the federal sovereignty. If his act is held unconstitutional under these circumstances, it usually means that the federal government, as an undivided whole, lacks power. A seizure executed by the president pursuant to an act of Congress would be supported by the strongest of presumptions and the widest latitude of judicial interpretation, and the burden of persuasion would rest heavily upon any who might attack it. 2. When the president acts in absence of either a congressional grant or denial of authority, he can only rely upon his own independent powers, but there is a zone of twilight in which he and Congress may have concurrent authority, or in which its distribution is uncertain. Therefore, congressional inertia, indifference, or quiescence may sometimes, at least as a practical matter, enable, if not invite, measures on independent presidential responsibility. In this area, any actual test of power is likely to depend on the imperatives of events and contemporary imponderables rather than on abstract theories of law. 3. When the president takes measures incompatible with the expressed or implied will of Congress, his power is at its lowest ebb. For then he can rely only upon his own constitutional powers, minus any constitutional powers of Congress over the matter. Courts can sustain exclusive presidential control in such a case only by disabling the Congress from acting upon the subject. Presidential claim to a power at once so conclusive and preclusive must be scrutinized with caution. For what is at stake is the equilibrium established by our constitutional system. Into which of these classifications does this executive seizure of the steel industry fit? It is eliminated from the first by admission, for it is conceded that no congressional authorization exists for this seizure. That takes away also the support of the many precedents and declarations which were made in relation, and must be confined to this category. Can it then be defended under flexible tests available to the second category? It seems clearly eliminated from that class because Congress has not left seizure of private property an open field, but has covered it by 3 statutory policies inconsistent with this seizure. In cases where the purpose is to supply the needs of the government itself, 2 courses are provided. 1. Seizure of a plant which fails to comply with obligatory orders placed by the government, Another, condemnation of facilities, including temporary use under the power of eminent domain. The third is applicable where it is the general economy of the country that is to be protected rather than exclusive governmental interests. None of these were invoked. In choosing a different and inconsistent way of his own, the president cannot claim that it is necessitated or invited by failure of Congress to legislate upon the occasions, grounds, and methods for seizure of industrial properties. This leaves the current seizure to be justified only by the severe tests under the third grouping, where it can be supported only by any remainder of executive power after subtraction of such powers as Congress may have over the subject. In short, we can sustain the president only by holding that seizure of such strike-bound industries is within his domain and beyond control by Congress. Thus, this court's first review of such seizures occurs under circumstances in which leave presidential power most vulnerable to attack and in the least favorable of possible constitutional postures. I did not suppose, and I am not persuaded, that history leaves it open to question, at least in the courts, that the executive branch, like the federal government as a whole, possesses only delegated powers. The purpose of the Constitution was not only to grant power, but to keep it from getting out of hand. However, because the president does not enjoy unmentioned powers, does not mean that the mentioned ones should be narrowed by a bad construction. Narrow construction? Some clauses could be made almost unworkable, as well as immutable, by refusal to indulge some latitude of interpretation for changing times. I have heretofore, and do now, give to the enumerated powers the scope and elasticity afforded by what seem to be reasonable practical implications instead of the rigidity dictated by a doctrinaire textualism. The Solicitor General seeks the power of seizure in 3 clauses of the executive article. The first reading, the executive power shall be vested in a President of the United States of America. Lest I be thought to exaggerate, I quote the interpretation which his brief puts upon it. In our view, this clause constitutes a grant of all the executive powers of which the government is capable. If that be true, it is difficult to see why the forefathers bothered to add several specific items, including some trifling ones. The example of such unlimited executive power that must have most impressed the forefathers was the prerogative exercised by George III, and the description of its evils in the Declaration of Independence leads me to doubt that they were creating their new executive in his image. Continental European examples were no more appealing, and if we seek instruction from our own times, we can match it only from the executive powers in those governments we disparagingly describe as totalitarian. I cannot accept the view that this clause is a grant in bulk of all conceivable executive power, but regard it as an allocation to the presidential office of the generic powers thereafter stated. The clause on which the government next relies is that the president shall be commander-in-chief of the Army and Navy of the United States. These cryptic words have given rise to some of the most persistent controversies in our constitutional history. Of course, they imply something more than an empty title. But just what authority goes with the name has plagued presidential advisors who would not waive or narrow it by non-assertion, yet cannot say where it begins or ends. It undoubtedly puts the nation's armed forces under presidential command. Hence, this loose appellation is sometimes advanced as support for any presidential action, internal or external, involving use of force. The idea being that it vests power to do anything, anywhere, that can be done with an army or navy. That seems to be the logic of an argument tendered at our bar, that the president, having, on his own responsibility, sent American troops abroad, derives from that act affirmative power to seize the means of producing a supply of steel for them. To quote, perhaps the most forceful illustration of the scope of presidential power in this connection is the fact that American troops in Korea, whose safety and effectiveness are so directly involved here, were sent to the field by an exercise of the president's constitutional powers. Thus, it is said, he has invested himself with war powers. I cannot foresee all that it might entail if the court should endorse this argument. Nothing in our Constitution is plainer than that declaration of a war is entrusted only to Congress. Of course, a state of war may in fact exist without a formal declaration, but no doctrine that the court could promulgate would seem to me more sinister and alarming than that a president whose conduct of foreign affairs is so largely uncontrolled and often even is unknown can vastly enlarge his mastery over the internal affairs of the country by his own commitment of the nation's armed forces to some foreign venture. I do not, however, find it necessary or appropriate to consider the legal status of the Korean enterprise to discount Tesson's argument based on it. Assuming that we are in a war de facto, whether it is or is not a war de jure, does that empower the commander in chief to seize industries he thinks necessary to supply our army? The Constitution expressly places in Congress power to raise and support armies and to provide and maintain a navy. This certainly lays upon Congress primary responsibility for supplying the armed forces. Congress alone controls the raising of revenues and their appropriation and may determine in what manner and by what means they shall be spent for military and naval procurement. I suppose no one would doubt that Congress can take over war supply as a government enterprise. On the other hand, if Congress sees fit to rely on free private enterprise, collectively bargaining if Congress sees fit to rely on free private enterprise, collectively bargaining with free labor for support and maintenance of our armed forces, can the executive, because of lawful disagreements incidental to that process, seize the facility for operation upon government-imposed terms? There are indications that the Constitution did not contemplate that the title Commander-in-Chief of the Army and Navy will constitute him also Commander-in-Chief of the country, its industries, and its inhabitants. He has no monopoly of war powers, whatever they are. While Congress cannot deprive the President of the command of the Army and Navy, only Congress can provide him an Army or Navy to command. It is also empowered to make rules for the government and regulation of land and naval forces, by which it may to some unknown extent impinge upon even command functions. That military powers of the commander-in-chief were not to supersede representative government of internal affairs seems obvious from the Constitution and from elementary American history. Time out of mind, and even now in many parts of the world, a military commander can seize private housing to shelter his troops. Not so, however, in the United States. For the Third Amendment says, "No soldier shall, in times of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." Thus, even in wartime, his seizure of needed military housing must be authorized by Congress. It also was expressly left to Congress to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Such a limitation on the command power, written at a time when the militia, rather than a standing army, was contemplated as the military weapon of the Republic, underscores the Constitution's policy that Congress, not the executive, should control utilization of the war power as an instrument of domestic policy. Congress, fulfilling that function, has authorized the President to use the Army to enforce certain civil rights. On the other hand, Congress has forbidden him to use the Army for the purpose of executing general laws, except when expressly authorized by the Constitution or by act of Congress. While broad claims under this rubric often have been made, advice to the President in specific matters usually has carried overtones that powers, even under this head, are measured by the command functions usual to the topmost officer of the Army and Navy. Even then, heed has been taken of any efforts of Congress to negative his authority. We should not use this occasion to circumscribe, much less to contract, the lawful role of the President as Commander-in-Chief. I should indulge the widest latitude of interpretation to sustain his exclusive function to command the instruments of national force, at least when turned against the outside world for the security of our society. But when it is turned inward, not because of rebellion, but because of a lawful economic struggle between industry and labor, it should have it should have no such indulgence. His command power is not such an absolute as might be implied from that office in a militaristic system, but is subject to limitations consistent with a constitutional republic whose law and policy-making branch is a representative Congress. The purpose of lodging dual titles in one man was to ensure that the civilian would control the military, not to enable the military to subordinate the presidential office. No penance would ever expiate the sin against free government of holding that a president can escape control of executive powers by law through assuming his military role. What the power of command may include, I do not try to envision, but I think it is not a military prerogative. Without support of law, to seize persons or property because they are important or even essential for the military and naval establishment. The third clause, in which the Solicitor General finds seizure powers, is that he shall take care that the laws be faithfully executed. That authority must be matched against the words of the Fifth Amendment, that no person shall be deprived of life, liberty, or property without due process of law. One gives a governmental authority that reaches so far as there is law. The other gives a private right that authority shall go no farther. These signify about all there is of the principle that ours is a government of laws, not of men, and that we submit ourselves to rulers only if under rules. The Solicitor General, lastly, grounds support of the seizure upon nebulous inherent powers never expressly granted, but said to have accrued to the office from the customs and claims of preceding administrations. The plea is for a resulting power to deal with a crisis or an emergency according to the necessities of the case. The unarticulated assumption being that necessity knows no law. Loose and irresponsible use of adjectives colors all non-legal and much legal discussion of presidential powers. Inherent powers, implied powers, incidental powers, plenary powers, war powers, and emergency powers are used often interchangeably and without fixed or ascertainable meanings. The vagueness and generality of the clauses that set forth presidential powers afford a plausible basis for pressures within and without an administration for presidential action beyond that supported by those whose responsibility it is to defend his actions in court. The claim of inherent and unrestricted presidential powers has long been a persuasive dialectical weapon in political controversy. While it is not surprising that counsel should grasp support from such unadjudicated claims of power, a judge cannot accept self-serving press statements of the attorney for one of the interested parties as authority in answering a constitutional question, even if the advocate was himself. But prudence has counseled that actual reliance on such nebulous claims stops short of provoking a judicial test. The Solicitor General, acknowledging that Congress has never authorized the seizure here, says practice of prior presidents has authorized it. He seeks color of legality from claimed executive precedents, chief of which is President Roosevelt's seizure on June 9, 1941, of the California plant of the North American Aviation Company. Its superficial similarities with the present case, upon analysis, yield to distinctions so decisive that it cannot be regarded as even a precedent, much less an authority for the present seizure. The appeal, however, that we declare the existence of inherent powers ex necessitate to meet an emergency asks us to do what many think would be wise, although it is sometimes the forefathers omitted. They knew what emergencies were, knew the pressures they engender for authoritative action, knew, too, how they afford a ready pretext for usurpation. We may also suspect that they suspected that emergency powers would tend to kindle emergencies. Aside from suspension of the privilege of the writ of habeas corpus in time of rebellion or invasion, when the public safety may require it, they made no express provision for exercise of extraordinary authority because of a crisis. I do not think we rightfully may so amend their work, and if we could, I am not convinced it would be wise to do so. Although many modern nations have forthrightly recognized that war and economic crises may upset the normal balance between liberty and authority, their experience with emergency powers may not be irrelevant to the argument here that we should say that the executive of his own volition can invest himself with undefined emergency powers. Germany, after the First World War, framed the Weimar Constitution designed to secure her liberties in the Western tradition. However, the President of the Republic, without concurrence of the Reichstag, was empowered temporarily to suspend any or all individual rights if public safety and order were seriously disturbed or endangered. This proved a temptation to every government, whatever its shade of opinion, and in 13 years, suspension of rights was invoked on more than 250 occasions. Finally, Hitler persuaded President von Hindenburg to suspend all such rights, and they were never restored. The French Republic provided for a very different kind of emergency government known as the state of siege. It differed from the German emergency dictatorship, particularly in that emergency powers could not be assumed at will by the executive, but could only be granted as a parliamentary measure. And it did not, as in Germany, result in a suspension or abrogation of law, but was a legal institution governed by special legal rules and terminable by parliamentary authority. Great Britain also has fought both world wars, under a sort of temporary dictatorship created by legislation. As Parliament is not bound by written constitutional limitations, it established a crisis government simply by delegation to its ministers of a larger measure than usual of its own unlimited power, which is exercised under its supervision by ministers whom it may dismiss. This has been called the high water mark in the voluntary surrender of liberty. But, as Churchill put it, Parliament stands custodian of these surrendered liberties, and its most sacred duty will be to restore them in their fullness when victory has crowned our exertions and our perseverance. Thus, parliamentary control made emergency powers compatible with freedom. This contemporary foreign experience may be inconclusive as to the wisdom of lodging emergency powers somewhere in a modern government, but it suggests that emergency powers are consistent with free government only when their control is lodged elsewhere than in the executive who exercises them. That is the safeguard that would be nullified by our adoption of the inherent powers formula. Nothing in my experience convinces me that such risks are warranted by any real necessity, although such powers would, of course, be an executive convenience. In the practical working of our government, we already have evolved a technique within the framework of the Constitution by which normal executive powers may be considerably expanded to meet an emergency. Congress may and has granted extraordinary authorities, which lie dormant in normal times, but may be called into play by the executive in war or upon proclamation of a national emergency. In 1939, upon congressional request, the Attorney General listed 99 such separate statutory grants by Congress of emergency or wartime executive powers. They were invoked from time to time as need appeared. Under this procedure, we retain government by law, special temporary law, perhaps, but law nonetheless. The public may know the extent and limitations of the powers that can be asserted, and persons affected may be informed from the statute of their rights and duties. In view of the ease, expedition, and safety with which Congress can grant and has granted large emergency powers, certainly ample to embrace this crisis, I am quite unimpressed with the argument that we should affirm possession of them without statute. Such power either has no beginning or it has no end. If it exists, it need submit to no legal restraint. I am not alarmed that it would plunge us straight away into dictatorship, but it is at least a step in that wrong direction. As to whether there is imperative necessity for such powers, it is relevant to note the gap that exists between the president's paper powers and his real powers. The Constitution does not disclose the measure of the actual controls wielded by the modern presidential office. That instrument must be understood as an 18th century sketch of a government hoped for, but not as a blueprint of the government that is. Vast accretions of federal power, eroded from that reserved by the states, have magnified the scope of presidential activity. Subtle shifts take place in the centers of real power that do not show on the face of the Constitution. Executive power has the advantage of concentration in a single head in whose choice the whole nation has a part, making him the focus of public hopes and expectations. In drama, magnitude and finality His decisions so far overshadow any others that almost alone he fills the public eye and ear. No other personality in public life can begin to compete with him in access to the public mind through modern methods of communication. By his prestige as head of state and his influence upon public opinion, he exerts a leverage upon those who are supposed to check and balance his power, which often cancels their effectiveness. Moreover, rise of the party system has made a significant extra-constitutional supplement to real executive power. No appraisal of his necessities is realistic which overlooks that he heads a political system as well as a legal system. Party loyalties and interests, sometimes more binding than law, extend his effective control into branches of government other than his own, and he often may win, as a political leader, what he cannot command under the Constitution. Indeed, Woodrow Wilson, commenting on the president as leader both of his party and of the nation, observed, "If he rightly interpret the national thought and boldly insist upon it, he is irresistible. His office is anything he has the sagacity and force to make it." Sagacity? Sagacity? I cannot be brought to believe that this country will suffer if the court refuses further to aggrandize the presidential office, already so potent and so relatively immune from judicial review, at the expense of Congress. But I have no illusion that any decision by this court can keep power in the hands of Congress, if it is not wise and timely in meeting its problems. A crisis that challenges the president equally, or perhaps primarily, challenges Congress. If not good law, there was worldly wisdom in the maxim attributed to Napoleon that the tools belong to the man who can use them. We may say that power to legislate for emergencies belongs in the hands of Congress, but only Congress itself can prevent power from slipping through its fingers. The essence of our free government is leave to live by no man's leave, underneath the law, but to be governed by those impersonal forces which we call law. Our government is fashioned to fulfill this concept so far as humanly possible. The executive, except for recommendation and veto, has no legislative power. The executive action we have here originates in the individual will of the president and represents an exercise of authority without law. No one, perhaps not even the president, knows the limits of the power he may seek to exert in this instance, and the parties affected cannot learn the limit of their rights. We do not know today what powers over labor or property would be claimed to flow from government possession if we should legalize it. What rights to compensation would be claimed or recognized, or on what contingency it would end. With all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government, except that the executive be under the law, and that the law be made by parliamentary deliberations. Such institutions may be destined to pass away, but it is the duty of the court to be last, not first, to give them up. And we'll stop there for today. And as always, if there's any case you'd like me to read, just drop in the comments. We'd have to take a look. Thank you.